Hello, everyone. Happy Wednesday. Happy hump day. I hope today finds you well. As you know, my name is Janae Brown, and I am the founder and the senior publisher of Open Book Publishing. And at Open Book Publishing, we work with storytellers who want to repurpose their professional experience and their creative genius into page turning books. And so we created Dear Authors because we wanted to make sure that authors of nonfiction and fictional stories all know exactly what to do when it comes to all things publishing. So today is a very, very special day because we are having a much needed conversation with Open Book Publishing's favorite intellectual property lawyer, Miss Neidy Hornsby. Hi, Neidy. How are you?
I am good. How are you, Janae?
I'm well. And so, Neidy, for all the people who live under a rock, tell them who you are.
No, Rock, stop it. Okay, my name is Neidy Hornsby. I am the founder and CEO of Noir IP, and we are a business and trademark law firm, unapologetically focused on helping entrepreneurs safeguard their genius, right? Protect their intellectual property and all the amazing things that folks are out here creating. So excited to be here to have this conversation with you.
Absolutely. And I'm so glad that you are here because I'm sure, as you know, you get a lot of questions from authors and from people in general who have intellectual property. And so let's first start off by just setting the stage, right?
Yeah.
What is IP? What is intellectual property?
So this is my favorite topic, right? Because I
Okay.
think that so often when we use the word property, we think of tangible things that we can touch, right? We think, oh, my car is my property, my house is my property. And we oftentimes neglect the fact that our ideas
Mhm.
can be property too, and most of the time have real monetary value, right?
Correct.
So the law has carved out this unique area to protect just that, right? Protect intangible ideas that have monetary value. So from the creation of a brand and a business, a book, a piece of art, a piece of music, to bird diapers, which is
What?
a thing. These are all ideas that we creators need to make sure that we are leveraging the law in order to protect and monetize our thoughts.
Okay. Okay. So when it comes to this is my dummy understanding of IP. That's why we
Okay.
have Nady on the stage. So IP consists of, correct me if I'm wrong, copyright, trademarks, and patents. Is there anything else?
Yeah, so those are the most popular ones. There's also, trade secrets that we can talk about, but I think in my expertise, or in my, I should say, in my practice, what I see people usually operating within, it's those three, right? Those are the main ones that you're either in all three, you're in two, because when you think of intellectual property, there's this big umbrella, right?
Mhm.
Intellectual property, what we said earlier, is the protection of ideas, using the law to create safeguards around our thoughts and our ideas, right? Under
Mhm.
intellectual property, there are these buckets.
Right.
So think of them as vehicles, and each of them operates differently. They protect different types of ideas. So for the most part, yes, you are correct. We are usually operating in the patent, copyright, trademark space.
Okay. And can you explain to us what are the difference between those three buckets?
Glad to, because I often hear folks say things like, "Oh, that's a great slogan. I'm going to patent that," and it's like, no, no, no. Right, generally in the right area, you're talking IP, but no, that's not a patent, right? So I can give you just the brief overview, and we can talk more as we go, but when we talk patents, we're talking about the creation of something like a device, let's say, right?
Okay.
When you think about like the cell phone, we once had landlines, now we have cell phones. Like these are all devices and machines that change the way that something operated, or just a novel way of doing something, right?
Okay.
So you're operating in the patent space if that's what we're talking about. So the light bulb is a patent, and your phone, and even certain features on your phone are
Feature. So like an
considered.
app can be patent.
Right.
Okay.
So when you think about something novel, or you're just improving the way that something worked in a way that it is now something new, you're in
Mm-hmm.
the patent space, right? Copyright is all about create protection of creative works. So music, books, paintings, anything in the creative space, we're talking about copyrights. And then trademarks is all about brand protection. We're talking
Mm,
about your brand identity, your brand name, your slogan if you have one, your logo, sometimes even your brand colors. So when you think of T-Mobile, immediately you think pink, or Tiffany, that Tiffany blue.
mm-hmm.
These colors, brands are using them to identify themselves as the source of that good or service. So if you are thinking about how do I protect my brand, then you're operating in the trademark space. But you can see that the underlining theme, the through line here, is all about your idea and which vehicle you use to protect that.
To protect it. That's so interesting. I didn't know that we could trademark colors. And it makes so much sense because, to your point, like Tiffany's, like you can't use that blue, or you wouldn't even think to use that blue
But if
because
I
you just
say
think
Tiffany blue, you know
that.
exactly the blue I'm talking about.
Mm-hmm.
It's not
Yeah,
like navy blue. It's not like baby blue. I can't really describe the
it's
blue,
Tiffany's blue.
but you know what I'm talking
It's
about.
Tiffany's blue.
Right. So when you're able to identify the source by just seeing that thing, that symbol, that color, that when I say Whopper, are you thinking McDonald's or are you thinking Burger King, right? When
Yeah.
I say just do it, are you thinking Nike or are you thinking Reebok? It's telling you the source of that good or service. That's a trademark.
Very interesting. So for authors, we're thinking copyright to start, right? Because
For
there's so
sure.
many things that you can do after you write the
For
book.
sure.
So for the copyright itself,
Hmm.
we have nonfiction authors and we have fictional authors. So
Hmm.
fictional authors are telling a fictitious story, something that is
Hmm.
not real, could be based on a true story, but nevertheless it's a story. Versus nonfiction tends to be like information based, if you
Hmm.
will, or that's where your self help books will come in. So
Hmm.
you copyright them both. Yeah.
Right. Right.
And so, if you are a fictional author who might have characters on the cover of your book, or
Yeah.
has photography in the
Right.
inside of your book or on the covers of your book, what exactly needs to be copyrighted on the fictional side?
So, a couple of things that you want to think about before we even talk about the mechanics of the copyright.
Mhm.
One of the issues that I see a lot is, hey, I hired this person to design this character for me. I gave them the idea. I'm not an artist, right? They're the artist, but it was my idea. I described it. They sketched it. Who owns that? That's a
Good
great
question.
question, right?
Mhm. A really common question.
The creator, the person that actually drew it, technically, right, owns that copyright by virtue of creating the thing, right?
Okay.
We want to make sure that when we engage in those relationships as authors and we're having people create certain characters for us, that we are operating under a work for hire agreement, right? So that once this character is created and I have paid for it, I own the copyright to that character, right? Like
Yeah.
our relationship is now done, right? Because this was a work for hire situation. That's the first thing I think that we should think about. Like, who owns the copyright when you hire someone to create a creative work for you?
Right. The thing that's in your head. Hmm.
Right. Then, like you said, whether we're talking nonfiction or fiction, we need to copyright our stuff, right? We
Okay.
want to make sure that we have this golden ticket that says, hey, I created this book. I gave constructive notice to the world by going a step further and registering this book with the US Copyright Office, right? And
Mhm.
now I'm able to go into federal court to sue for infringement. So you want to absolutely copyright your books, whether fiction or nonfiction. I think the added step to think about when it comes to nonfiction is, are you creating characters that can stand on their own outside of that book? So, for example, Wonder Woman. or
Mm,
Hannibal Lecter, Fred Flintstone, right? These are all characters that can live outside of that original piece of work, right?
sure.
Um, and you want to be able to control where that character lives outside of that original work. You want to be able to create new work based on that character, and if that is the plan, if that is the intention, then this is more of a creative process situation. You want to make sure that the character does indeed stand on its own. So you saying to me, hey, my book is about an alien who is escaping some type of like
Dragon.
alien situation, and they land on Earth.
Mm-hmm.
Great. I love it. But does that stand on its own? I don't know, right? But if
Mm-hmm.
you say to me, hey, my alien has a really big head and a very thin neck and a light bulb for a finger, and it says, phone home. I don't know. Now we're getting into more descriptive, standalone characteristics where perhaps, you have a character that can live outside of the book. So they, I say that to say that, we are all creators and we're sensitive about our stuff, right?
Yes, Erica.
You may think that we have, fictional characters that can stand on their own, and then someone, writes a book that is very similar to our hero or our antagonist, but is it really a stand on its own level character is what you want to think about in order to create the argument that yes, this can live outside of the original work and therefore it should be afforded additional protection because I don't want to see this character pop up somewhere else. Does
So
that make sense?
then, in that sense, you'll get your book copyrighted and the character copyright.
Yeah,
Yes.
absolutely. And you want to be able to make sure, and the reason why is because you essentially don't want that character to live anywhere. So again, I think that those examples that I said, Fred Flintstone, you couldn't imagine using Fred Flintstone or Hannibal Lecter or Wonder Woman or Superman, in any way that violates that author, that creator's copyright, because they are absolutely standalone characters.
Okay,
So
so let me ask you this then, right? Because some before Freddie Flintstone was Freddie Flintstone, he was just Fred Flintstone, right?
Mhm.
So, or even Harry Potter, right? The author for Harry Potter had gotten turned down from multiple publishing houses
Mhm.
before she was able to publish Harry Potter. And now look at what it is. But before, he was just some character that nobody wanted to publish.
Mhm.
So, if you were to just publish the book and then the book does far exceeding than what you anticipated, could you go back and copyright Harry Potter,
Yeah,
or how
no,
does that
you
work?
yeah, so remember, you are the creator. So one of the interesting things about copyright that doesn't really exist in the other forms of IP protection is that by virtue, so if I grabbed a piece of paper right now and I drew a house on it, I have the copyright. The minute that that idea becomes tangible, so if I wrote a song and I record myself singing it, I have the copyright, right? So you always have the copyright the minute that that idea takes on physical, tangible form um, within the copyright space. The
Yeah.
copyright registration is just a step further, right? It's saying, I am essentially giving constructive notice to everyone because this is now filed with the US Copyright Office. So yeah, if you created this book and this character and you publish the book and then the character somehow blows up outside of the book, like going back to get to file that application is something that you can absolutely do because essentially you've already had the copyright. You already created the book. Does that make sense?
Yeah, and I'm glad that you said that because I've had some authors use Google and YouTube University, and they're like, "Don't I already am protected with the copyright because I did it?" Yes, is the answer. However, it's you still should take this extra layer of precaution and register, even though once you've created it, you've made it tangible, and now you are protected. Yes.
Yeah. So the main thing is how, if having the copyright is great, but being able to enforce it
Mm,
is the value of the
okay,
copyright.
that's good.
So you're giving yourself that added level of saying, not only did I create it, not only did I put it in tangible form, giving me the copyright automatically, but I registered it with the US Copyright Office, and therefore I can now sue you in federal court for infringement. So it's that ability to enforce the copyright, to just have the copyright is great, and there is definitely value to that, but being able to have that added level of enforceability
Yeah.
is what makes it worth the effort.
Yeah, that's good. That's good because I don't think people think that far because
Mhm.
stuff happens, as we know, stuff happens. So now you're able to enforce the copyright. So, yes, you have the copyright the moment that you write the book authors, but being
Mhm.
able to enforce it requires registration, right?
There you go.
So that's nonfiction side. So on the fiction, or I mean, excuse me, that's the fictional side. So on the nonfiction side, there aren't characters, right? But
Mhm.
sometimes there might be a photo shoot for your wonderful headshot to be on the cover of the book. That's where we get into the work for hire contract. Yes.
Yeah, so we have work for hire under both scenarios, right? So I know
Mm-hmm.
that if I ever wrote a nonfiction book, there's no way that I could even embark on creating my character. So there's a work for hire there. Photo shoots, there's a work for hire there. The person that takes the photograph owns the photo, unless there's a work for hire understanding agreement that yes, you took the photos, but I own the photos, and and when it comes to photos in part, you know how many photos have significant monetary value because they're part of history. So there's always an incentive to, the way I like the best way to explain it is, I think that oftentimes as creators we get really excited with the fun stuff. The fun stuff is like getting the book out, right? Like that's the fun stuff, the marketing strategy around it. But we can't let excitement overshadow strategy, right? We imagine launching a book and then having the photographer claim the copyrights to that photo. These are all legal issues that can be avoided by just pausing for a moment and being strategic, and putting on both hats, the creative hat, and also being strategic about how you move and how you protect and create parameters around this thing that you're building.
That's good. That's good. And so I just had a random thought. There are times where on both types of author, rather fiction or nonfiction, everybody needs an editor and everyone needs a book formatter, a designer to
Mhm.
format your book. And there are times where, in order for your editor or your book formatting designer to get work, they have to have samples.
Mhm.
How does that work with IP? Can I say I don't want my editor to use my chapter to show another author that they could edit? How
Yes,
does
yes, and
that
yes,
work?
and yes, and yes, and yes. These are all, so that's you being strategic about how you're moving. So I once heard a quote that I love when it comes to contracts and having things in writing, and it was, um, contracts are the scripts we follow when things don't work out, right?
Mm,
And the reason why I love that quote is because in the beginning, with most ventures, it's like everybody's in love and it's going to be great, and you're going to be my editor, and the relationship is going to be amazing. And then if it's not,
then what?
then what, right?
Uh-huh.
So when you have agreements in place, when things don't work out, if things don't work out, because that's always a possibility, you're dealing with human beings and we're fickle, right? Now we have this document that governs what happens next. Now that this thing that we were working on fell apart, who owns what are my responsibilities, what are your responsibilities? So it's always very prudent and thoughtful to have an agreement with anyone that you're working on. I'm dealing with this is not copyright related, but I'm dealing with a situation right now where someone hired an app developer, very reputable app developer, who is now developing a very similar, almost identical app to what the client hired them to do. And my first question is, okay, well, let's look at the contract and let's see what the parameters and expectations were. there's no contract.
Wow.
So that makes the job of the attorney, whoever it is, just that much harder, when in reality it could have been a very straightforward agreement that details what the expectations are. Hey, there's a non-disclosure clause. I
Mm-hmm.
share information with you that cannot leave the scope of this relationship.
Right.
Maybe not a non-compete conversation, but what I'm saying is that the law has been here before, right? And there's already something that we can use to legally protect whatever it is that you're working on. So to your question, Janae, yeah, if you're working with anyone who is handling your idea, it would be, thoughtful of you to
Yeah.
make sure that you are just taking the precautions
And
needed.
you will put the work for you to have an editor who couldn't sample your work, or a formatter who couldn't use your stuff on their website. That will be in the work for hire agreement. Is that correct?
Yeah. So work for hire agreement would cover like who owns what once the person or the service provider creates, the character or creates whatever creative work they are doing. I think
Okay.
more so when it comes to the editor piece, if for you as an author that's a concern, like, hey, I don't want you as an editor to share my writing with anybody
Mhm.
else, or to even use it for your own promotion in any way. These are all terms that you can come to an agreement before you're even sharing your stuff, so that and by the way, you want that for just peace of mind. Imagine working with someone. So I don't know how long like the editing process works, but I'm assuming, well, I guess it depends on the nature of the book. But let's just say that you're working with this person for the next 6 months to a year. You want to be able to confidently move and navigate those conversations,
Mhm. Mhm.
unencumbered by the fear of like, where's my stuff living? Like, you know what I mean? Like that, it
Absolutely.
hinders the relationship, really.
Absolutely. And so Tanisha, hi Tanisha, she commented and she asked the question, where will we find the information or template to do a work for hire agreement?
So that makes my stomach hurt a little bit. And I'll
Okay.
tell you why. Because you can find a template by just going to Google, like you said, Google University.
Mm-hmm.
And I understand that, in the beginning, sometimes that has to be the hustle, because what comes first, the revenue to hire the attorney in order to protect the revenue source, chicken egg situation. So if you Google, you can find template. I can't vouch for what is on the internet, you know.
Yeah.
I can't vouch for how legally valid it is. I can't vouch for, whether it actually holds any legal weight in court. So the answer is you can probably find templates on Google. Can you trust the legal strength behind them? I don't know.
Yeah. Yeah. The truth of the matter is, get it. Well, this is the question, right? And we're getting ahead of ourselves, but when does an author need an IP lawyer? Does an author need an IP lawyer?
Listen, I think everybody in business needs an IP lawyer. So I read recently that 50%, almost 50% of all businesses assets are all intangible IP related. So whether they have
Mm,
copyrights, they have trademarks, they have patents, so much of the business's value is tied to IP.
right.
When you think about those numbers, that's staggering.
It's half of your business.
Yeah, so that means that a lot of us are out here building brands that have, some type of legal hole, because we haven't thought about all the ways that we can protect what we're doing. So I
Mhm.
think that everyone that is creating anything, if you're creating a business, if you're creating some type of creative work, if you're creating a device, it's just it's
Necessary.
just necessary
Mhm.
to have the conversation
Yeah,
with
at bare minimum.
at the bare minimum with someone who has the knowledge and knows, how the law can serve you and what you are doing. So at the very minimum, I think a conversation is
Mhm.
warranted.
Yeah,
Sometimes you know what you don't know.
Right. And I think that, and I understand, especially for first time authors, when you first are starting, to your point, you are thinking about revenue. And I think a lot of times that we have to change our mindset that we're not paying a cost and it's not a price, but it's an investment,
Mhm.
because the absence of protection can cost you
So much more.
so much more. Like if I tell y'all how I met Nady and I was like in tears, like, save my company, it didn't have to be that way if I
Right.
would have gotten the legal protection in the beginning in 2018, 2019, when the open book publishing starts. Now Nady got us so airtight, you can't do nothing. But
I think the issue is that I say this all the time. IP is not sexy. Like I get it.
yeah,
I absolutely understand that. And I have my own business, and the fun part is the marketing, branding, launch party stuff. Like that's the fun part.
yeah.
But to build something that has no foundation, and you have to think about legal considerations as the floor of what you're building. If you have no ground floor, what is everything sustained on?
Right, it's gonna sink. It's gonna sink. So we talked a lot, Nady, about, I would say, the preliminary stages of becoming an author, the very beginning. And so there's so much that you can do after you publish your book on the nonfiction and the fictional side. So when it comes to like fiction, you can transition your book into a cartoon, you can
Hmm.
transition your book into a series. You can even start teaching creative writing courses about how to do character development.
Yeah.
And then on the the nonfiction side, you can leverage your book for coaching programs. You can leverage your book for speaking engagements. You can leverage your book as a textbook and for a course if you even wanted to. So, like, tell us now beyond the book, right? Once you have written the book, and for let's start with nonfiction this time. We are now saying, I want a coaching program. What needs to be trademarked? Or if you have a phrase that you're using all the time, um, a program, a speaking topic that now you have coined it as one specific name that you're doing every time you're having a speaking engagement, a
Yeah.
coaching program. And what I was asking you the other day, a framework, right?
Hmm.
If you're building a curriculum to accompany your coaching program, or if you're just selling the framework to another organization, how do you protect yourself beyond the book with your IP?
Yeah, so all of the examples, or most of the examples that you just mentioned, transition us into a trademark conversation, which is equally as important, right? So if you have now, you wrote your book and it's a successful book, and you are now transitioning into other derivative works that are based on that. So to your point, a coaching program, if from that book, now there's a tagline that you are constantly using for your content and for your whatever programs you're putting out there into the world. We're talking brand protection, right?
Mm-hmm.
Because within trademark, you can protect taglines, colors, brand names, all the things that we talked about earlier. Why does that matter? Well, if you are using a tagline to identify yourself as the source of this particular workshop or framework or coaching service, then you want to make sure that you are the only one using that name or any variation of it. So the best example to discuss the importance of trademarks is, sometimes people say to me, well, I don't really need a trademark because I have an LLC.
Mm.
My name is protected as an LLC. Well, there's some truth to that, right? If you are an LLC and you're using your name, yeah, your name is protected in your state,
Okay.
which is great, but the internet has removed state borders. I have clients all over the country. You're probably working with folks all over the country. We want to make sure that our brand identity is protected, not just in our state, but across the country, right?
Yeah.
And the trademark registration offers us as entrepreneurs, as creators, that level of protection. Not only does it protect the name or the slogan as is, but it protects any variation of it that might be confusing. Like that's the beauty of trademarks, right? Not only am I protecting, so our firm name is Noir IP. Not only am I protecting Noir IP, but I am protecting IP Noir or the Noir IP or any variation where the consumer is going to be confused. Like,
Mm,
so who's who, right? That gives me, as someone who is building this firm, a lot of leverage to control where my brand identity lives and to stop folks that would try to capitalize on the effort or on what I'm building. So that's the beauty of owning your trademark registration. One, you're protecting your name or your brand identity on a national level, but you're also essentially protecting any variation of it that is just too close that can create confusion in the marketplace. I can't imagine building anything and just saying, oh, I can wait on that level of protection.
mm. That's real. That's real.
You know what I'm saying?
1,000%, because I'm thinking I have so many authors who come with the idea to have a coaching program and they're just writing the book to leverage themselves. Like, don't really even
Mm-hmm.
care about the book, right?
Mm-hmm.
And so concepts in the book that you will use as taglines or frameworks, we're saying that those need to be trademarked.
Yeah, especially if the whole point of you using that tagline is to, again, identify yourself as the source of that
Yeah.
service. If that's the intent behind that tagline or that brand name or that logo, you need to have a conversation about how to protect that brand asset through the trademark process, because
The
again,
trademark.
it's an actual asset, right? If you decided to sell the business, now you're saying, I'm not only selling the business, I'm selling the business plus its trademarks, because that's
Mm,
property. You see what I'm
okay.
saying?
Yes,
Like saying I'm
property.
selling the business and the office building because that's property. Yeah. So is the trademarks that you own.
Right. So how does that work if a author wanted to now leverage their book for speaking engagements? Where is there any IP conversations or protection that they need to be thinking about for speaking engagements?
Generally speaking, with speaking engagement, so that's a very case by case scenario, right?
Okay.
If you are talking about things that you have already protected through the copyright process, you're more than likely covered in that regard. So again, it goes back to, what are you doing up front in order to be able to move forward without these fears of like, oh, you know what, I'm about to get on stage and I'm about to talk about this framework, but the framework hasn't gone through the copyright process, or I'm about to mention this brand name but I haven't gone through the trademark process. It's all about having these conversations up front,
Mm-hmm.
creating these
Yeah.
legal parameters up front, so that, yeah, when you get that speaking engagement to talk about that book that you already copied, you went through the copyright process,
It's covered. And
you're
the
good.
reason why I asked about speaking is because oftentimes, again, the company or the organization that's hosting the conference, for example, they might want to use real footage of your speaking to promote post
Mhm.
conference. People might ask for your slides of your presentation. People sometimes I've seen, and I was like, absolutely not. There was a client that I had who their presentation was a part of the kit to give as a gift to the guest afterwards without their consent. And I was
That's
like,
wild.
absolutely not. We're not doing that. When I was like, I don't even have to call Neidy, but that's a thing,
But
right?
see, now we're going back. Do you see how all of these things work together? Right now, we're going back to the contract conversation, right?
Mhm.
So if you are asking me to speak at your event, I want something in writing that, So this presentation that I'm sharing with you, it's not for you, it's not to be shared, as part of what you just said, like the kit, the welcome basket, or is this is a standalone piece, right? You can't put it on your website, you can't use it, whatever the case may be, or you may want certain footage used to promote because it promotes you as well. But
Mhm.
whatever those details are, it's just easier to get them clarified in the beginning and then put them in writing. It's
Yeah.
not what you know, it's not what you heard, it's what you're able to prove. So if you're saying, look, I am going to have a slide presentation, but that is not part of that, that's my intellectual property, and that we're going to use it very limited in scope as far as like my speaking opportunity, but it's not to be used outside of that, well, put that in writing so that there's a clear understanding of what the expectations are, because contracts are the scripts we follow when things don't work out the way that we expected them to.
We need that on a shirt somewhere.
Listen, when I so it's not my quote. I don't even know. I heard it at a conference, and it's like, oh wow, that's the best way for people to
Mhm.
understand. Because again, these relationships and opportunities are all really great in the,
Mhm.
and you just
Mhm.
never know where it can go. I also think that when you're starting, every opportunity sounds like I gotta do that. I got
Yeah.
and maybe you do, but if you do, again, you want to make sure that you're moving in a strategic manner.
Okay, so now let's talk fictional authors' life after the book, right? So they could have a comic book series, they can have a YouTube
A
series, they
movie.
could make a movie. They can even make a series, for example, Harry Potter. There's like 80,000 of them, right? So for that,
I never got into Harry Potter. Is that like a violation of like the publishing world? Okay, 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 good. We're on the same
like
page.
we're not on camera. But I have not either. But there are several other, or even you don't even have to do Harry Potter. We can do urban fiction and urban romance, right?
Mhm.
There are 50,000 Zane books. There are several you know what I mean? What's the other one that I love? The Coldest Winter Ever.
Oh,
Right there,
this
we
one.
love the coldest winter ever growing up. Now there's a part two, there's a
Yeah.
series. So the first question is, should an author, a fictional author, make their book into a series? Do they need to file a copyright for each of the series, each enter of
Yeah.
the series?
So
Hmm.
you definitely want to do that, but a series brings up an interesting point as well, because when the book is a series, you are also technically able to file for a trademark, right? So
Okay.
if you had a single book, right, that doesn't fall within trademark protection, right? But if you have a series of books, so Harry Potter's a good one. What's the one with the advice for teens? Um,
Chicken soup.
Chicken Soup.
Hmm.
Chicken Soup is another one, right? Where there's like a series of different books. So if you are an author and you are creating books that have a series to it, then you're also potentially in the trademark space. So you want to think about, okay, I need to trademark the title, right? Like, because this is now a series of books, but I also have to copyright the underlining creative work. So now you're operating in two of the buckets that we talked about as far as intellectual property.
Okay. And so, really quick, if an author needs a copyright or a trademark, how do they go and get these things?
They go to IG and they go to Guard Your Genius and they find me, right? And then
That's
they
what I
send
do.
me a PM, and then we can, figure out next steps. But, you want to have a conversation with an attorney is
Mhm.
the only thing that I can say. Because you don't know what you don't know. I have people that are writing books, and then after having a conversation, they realize that, oh, wow, this is more of a trademark situation as well as a copyright. So again, the law has created these vehicles for us to safeguard our genius, and we should.
And we 1,000% should. Nady, this has been like so eye-opening
Thank
because
you.
of course, because a lot of people are not thinking about intellectual property until they have a company.
Right.
And a lot of authors, and I say this all the time, I don't care if you're traditional, self published, or hybrid publishing, there is a strong element of entrepreneurship that's connected to your book, right? And
Hmm.
so you, in my opinion, everyone becomes an authorpreneur. Everyone,
I like
with
that
or
opportunity.
without traditional publishing, you become an
Hmm.
entrepreneur. The benefits and the impact of your book is solely based upon you. And so just because of that, you're already entering into the business space and need to start having these conversations about intellectual property because your book is so rich with wealth.
Yeah.
Right, you can do so much with it, which will translate into a business, and therefore you would need Neidy.
Or someone like me, at the end of the day, I think it's just so important because there are so many of us out there doing this very important work. So if it's not me, just someone that can give you some guidance. You're the creator, right? Let someone handle the legal part of it.
For sure, for sure. And so, Nady, tell us, IP, are we
Mhm.
now saying officially that our recommendation is that you need to at least have the conversation, and then after the conversation, you need to have a real conversation or in-depth more conversation about contracts because that's where everything starts.
Absolutely. And I think so. The way that we handle our consultations is that we want to know the world of what you are building so that we can say to you, okay, here's all the spaces that you're operating in, whether you knew that or not. And here are the contracts that you need to govern those conversations that you're having. And here
Mhm.
are the IP avenues that you have at your disposal to protect this, and which differs from that. So you walk away with this legal roadmap of how to move forward, whether you move forward with us, but now you still have this understanding of the spaces that you are operating in and the tools available to you in order to move forward in a thoughtful, strategic manner.
In a strategic manner because like we talked about earlier, as a first time author or first time anything, business, anything, you're concerned about the money, which
Yeah.
is understandable,
Yep.
but you really have to switch your mindset into investing,
Yep.
because editing could range from $1,000 to $3,000. A
Hmm.
graphic designer for your characters could range from $750 to $2,500. And if you are putting this amount of money into a product, you need to make sure that it's protected and that it's protected right. Knock on wood. Maybe nothing will happen if you file a copyright on your own,
Yeah.
but then you're gonna call Navy 10 years later if something does. And so I
And that fee looks a lot different when we are on defense versus offense, right?
Mhm.
So I don't
I,
know.
I, I highly, as a person who started just as an author, just as an editor, and then life happened, things that I never even thought was a thing. I was like, how was she even able to do that? Because I needed to have the conversation. And then I also needed to make sure that our contracts were together so that it's not a thing later. And,
Yeah.
and then I also think be mindful, authors, that it's really like a one-time investment. Like once you have an airtight contract, you're just repurposing that contract. Once you have the copyright, it's done. It's not like something that you're continuing. So I definitely think incorporating an IP lawyer into your publishing team and your publishing community is definitely something that is 1,000% necessary. 1,000%.
1,000%.
1,000%. Well, Nady, thank you so much for joining us and
No,
dropping
thank
all of these
you.
jewels.
Thank you. Thank you for having me. I love talking about this stuff because it's important.
Absolutely. So, Nady, tell the people where can they connect? How could they follow up with you?
So the easiest way is on Instagram on at guard your genius. See what we did there.
Yep.
Our DMs stay open. There's a link in that in our bio to book a consultation. And we're here to serve. So let us know.
Absolutely. And you guys know that you could connect with Open Book Publishing with all of the information listed below. We're on Facebook, Instagram, and LinkedIn as Open Book Publishing. And then, as always, authors, we always close with a good tip. And so, dear authors, our tip for today is to guard your genius.
I love
Do-
it. Love
Guard
it.
your genius. Do not
I
allow
love
for
it.
yourself to second guess yourself or to wonder what could happen later. Just protect it right now and guard your genius. Have a conversation with an intellectual property lawyer. Get your contracts together, get your copyrights together, get your trademarks together, get all things together because authorship is a business. So guard your genius. All right, good people. Thank you for another wonderful episode of Dear Authors. We are here every Wednesday at lunch. It's your favorite lunch and learns. That's when you are able to connect with service providers, publishing professionals, and other published authors to learn the ins and outs of all things book writing and book publishing. Until next time, good people, guard your genius.
Are your genius.
See you later. Have a good
Bye.
one.